and we'll just chit chat about everything forever. So I'll begin the recording. So welcome everybody. Happy Friday and happy 14th Amendment Conversation Day. We are so excited to have you all in here and our different age groups coming into the class. The 14th Amendment is an amendment for all of us to talk about, discuss, and continue to learn. So today we're going to give you an exposure to how we got the 14th Amendment, as well as how it affects your life today. If you have questions during class, please feel free to put them in the chat or the Q&A, and we will look out for them. Today, we're going to have Jeff Rosen, our president and CEO at the National Constitution Center, lead us through this great conversation. But our VIP, amazing guest speaker today is Christopher Riano, who is an expert in the 14th Amendment and has written an amazing book on it called Marriage Equality: From Outlaws to In-Laws. That is awesome. It's a great read, and it's definitely really heavy if you need to combat anything with it. It's a win-win all around. But he's also the president of the Center for Civic Education, a wonderful partner with the National Constitution Center. Also, and Warren reminded me not to forget to share this, is an Eagle Scout and taught our scouts from the National Constitution Center last night on a panel to learn all about the law, history, and becoming an Eagle Scout. So ask him anything you want. And without further ado, I'll turn it over to Jeff Rosen.
Wonderful. Thank you so much, Curry, and welcome, Christopher. It is so great to see you. We're so lucky to be able to learn about the 14th Amendment from you. And I thought we'd begin with the text. I'll ask you, why did the framers pass the 14th Amendment? And then we'll take the big cases, starting with Plessy versus Ferguson, which upheld separate but equal, up to Brown, which overturned separate but equal in schools, and then the Loving case, which overturned bans on interracial marriage, and then all the way up to Obergefell, which you wrote about so movingly. How does that sound as a plan?
I think that's great. And Jeff, I'm just so excited to have a chance to, do this once again and have such a lively discussion about an amendment that I know you and I hold deep and share deep regard for because of its transformative effect on what America looks like.
What a beautiful way to put it. It was a transformative amendment, which transformed what America looks like. And let's begin with the text. Okay, I'm going to try to sort of do it from memory, so let's see how we do. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor deny to any person within its jurisdiction the equal protection of the laws, nor deny any person life, liberty, or property without due process of laws. Wow, I'm not sure exactly how good that was.
I think you did pretty well. I'm following along, Jeff, on my Constitution app. That was very well done.
Okay, well, there's a lot going on there, but what do you want our friends to know about the core reason that the 14th Amendment was passed after the Civil War?
I think in so many ways, and what I think about when I think about the 14th Amendment, the core reason it was passed is because we had a transformative moment in our society. We had gone through this truly, unique experience of having this Civil War where there was this big question following the Civil War of how state government and states interacted with the federal government and the federal landscape. And in many ways, we've had this debate our entire history as America. We had this debate when we had the Articles of Confederation, which were very loosely, federalized. You have the change that comes with the Constitution, that's much more strong federal government. And then the 14th Amendment fundamentally shifts that once again. And it really puts the states in a place where they now are bound by things like the Bill of Rights. They are bound in many ways to these core American concepts that they weren't before. And while that's happened over time, and the process that's happened with the incorporation process has happened over time and still is happening. In fact, there's been recent cases that deal with the 14th Amendment and incorporation. I think I'll say this, it is truly, if not the biggest, one of the biggest shifts in American history, because it shifts the structure of federal government. And that makes a huge difference in the way that our history unfolds afterwards.
That is such a crucial point. And you're so right to remind our friends that the central purpose of the 14th Amendment was to transform the relationship between Congress and the states. And as you say, the original understanding of John Bingham, who drafted the amendment, was to apply the Bill of Rights against the states. And yet the Supreme Court in the Slaughterhouse case failed to respect that original understanding and read the Privileges or Immunities Clause in such a cramped way that it took almost 100 years for that hope to come to pass. And for that reason, the first big cases that we see at the end of the 19th century dealing with the 14th Amendment have to do with state restrictions. And that brings us up to Plessy versus Ferguson, which is a remarkable case. In the 1890s. The southern states begin to require railroads to have separate cars for Black people and white people. Even when they don't want to do it, they have to do it because of the rise of Jim Crow. And the Supreme Court in the infamous Plessy versus Ferguson decision upholds that. Why did they uphold that? What was the reasoning, and what was Justice Harlan's reasoning for dissenting?
You know, that case is obviously one of the most incredible cases to read, especially today. And I think it shows the both kind of the reflexive intent that you get when you have a 14th massive change constitutionally, like you do in the 14th Amendment. And you can look in the 14th Amendment, and this comes up with students all the time, and students will say, these words are beautiful. The idea of equality, the idea of the Privileges and Immunities Clause, these things sound really amazing. The words sound amazing. You can go back to the original intent of many of the words and think about how amazing it is, but that doesn't equate to an immediate shift the way that we might have thought it could have or should have. In fact, if anything, you end up seeing the 14th Amendment looking very different than it does today. The word equal looks very different again than it does back when you see Plessy versus Ferguson. You can see a beautiful word like that, and you can see it turned and twisted into, sure, this is equal, except it's not, because it's separate. And I think that actually is an incredible example, and Plessy versus Ferguson is an incredible example of the dichotomy that can exist between looking at text, trying to understand what it means to parse out the words in the Constitution, why it's not as simple as just saying that word's in there, that word is right there, that word means something. And then really looking at the larger landscape of, sure, the word is in there, but how are we going to interpret that word? How does that word or phrase change the way that we're looking at these relationships? And of course, yes, the state level and federal level, but then of course, the relationships that we have as the people. And I think that's an incredibly important thing to think through. And Plessy is one of the greatest examples of, we pass this beautiful new amendment, there's this intent for radical change, and then maybe we don't quite get there. And I think that shows this incredible, it's one of the greatest showings of our constitutional history and how the pendulum constantly is swinging back and forth.
That's such a great way to put it. You can pass these beautiful words, but until we give them meaning, they fail to fulfill their promise. In Plessy, the majority said, well, if Black and white people presume to imagine that Black people are inferior because they have to sit in separate cars, that's just the construction they're putting on it. And Justice Harlan said, what are you talking about? Everyone knows what the real purpose of this law was, which wasn't just for the mutual convenience of both people, but to degrade and stigmatize Black people and suggest they weren't equal to whites. Why was Harlan the only one who recognized what he said everyone knows? And was Plessy wrong the day that it was decided, or did it take 100 years for people to catch up with Harlan's insight?
You know, I would say this, Jeff, and I think this is right at the core of one of my favorite reasons that for teaching constitutional law. You know, there are different theories on how to interpret the Constitution, and there's also different theories on how law works. And since we have such a range of folks with us today, I'll just simply say, you know, it is not as simple as pointing at a word, what we call positivism, and showing that there's a word that has positively been created to create a law or a statute or a rule or a constitutional concept, because you have to look at the realism. And it's another big picture concept that I'll just say for everybody who's with us today, it means that there's a reality of the world that we live within. There's a reality of the way that we look at things. And I think what you're noting about Justice Harlan and thinking about this case is you see that duality here of certain people pointing to words, certain justices pointing to certain words, interpreting them in a realism way that they see things. And Justice Harlan thinking, that's not what the 14th Amendment was intended to do. This obviously, from a realistic perspective, is not constitutional. This is not why we fought that war. This is not why Congress changed and the states changed this relationship. It's why I think the interesting dichotomies that exist when it comes to interpreting law are so fascinating. It's why I love when students and folks can point to words in any amendment, but then we can talk about, equality sounds lovely. It's literally probably one of the most beautiful phrases in the Constitution. And yet its tortured history has been anything but. And I think that's the realism that we have to always go into these conversations recognizing, because it is a continual conversation in a constitutional democracy.
That's such a great way to put it, that crucially important distinction between positivism, just the meaning of the words themselves, and realism. What do the words mean in context? And we've run through with our friends in this class the different methodologies of constitutional interpretation that you and I studied in law school, and that I'm so proud of our great students for grappling with, which include text. What did the word mean when it was ratified? History and original understanding. What were the paradigm cases that gave rise to it? Precedent, what has the Supreme Court said about it? Structure, how does it work with the other parts of the Constitution? Pragmatism, these prudential questions of balance and the effects of a decision. And then questions involving natural law and morality, which I know we're going to talk about in a sec. But all of those methodology, friends, as you're listening to Christopher and thinking about this class, are important to think about, because as Christopher says, it can affect the way you reach your conclusions. Okay, now we're going to take a big leap forward from 1896 to 1954, and it's time to decide Brown versus Board of Education, which struck down segregated schools, and Thurgood Marshall, who argued the case, reads Justice Harlan's dissenting opinion out loud to inspire himself before he argues the case. Tell us the story of Brown, what Thurgood Marshall argued, and how it was that the court came to overturn Plessy and to strike down segregation.
I mean, Brown is the case. Right. Brown is finally the 14th Amendment in some ways recognized. Brown, in so many ways, looking at racial discrimination in schools and segregation in schools, is the moment where so much actually changes from a constitutional perspective, but also from a legal perspective. It's one of the first cases where psychology and studies actually end up in front of the Supreme Court, which is fascinating to see the new tools and tactics that were used in order to try to convince the justices of the harms that existed because of what had come after Plessy. And I think in so many ways, it's an extraordinary shift from a constitutional perspective, because what you've done is, again, you haven't changed the text. The text has not changed. The original meaning of the text has not changed. Now, has a human rights concept of the text changed at that point? Probably, yeah. And has a realism concept changed in the way that we look at society? Yes, but here's something that's very special about Brown. Brown's one of the times where the Supreme Court, I think, sat down, looked at the case before it, looked at this very unique body of evidence when it's balancing things back and forth, and said that it was time that the world had changed, that it was time to make that change from a legal perspective. And the court has done this since, it most certainly has done this since, but it's one of the real first times that they start to look at themselves the way that they do today. And I think it is phenomenal. It's just phenomenal that you have the justices up there in unanimity saying, this is wrong. And it was wrong back then. We didn't get it right. Okay, but we're going to get it right today. And that will be the law of the land. That will be the law under the US Constitution, that you cannot segregate schools anymore. And you cannot have segregate. I mean, it's just fascinating that that's where that decision ended up being made, because the Supreme Court historically is not necessarily the protector of rights that we think it is. And yet it changed the landscape of America once again forever. ever. And the case kept coming back. And they kept saying, no, we've made our decision. We've made our decision. And I think it's an extraordinary showing of the fact that as Americans, we do not always get it right. We have a lot of things in our history that we have not gotten right. But generally speaking, we do better over time. We do move towards a more equal society. At least I think we try. We do try to move towards a more perfect union. I think it's an incredible example of that.
That's such a great way to put it. Not perfect, but we become more perfect over time. Justice Ginsburg had a wonderful word that she used to describe that same process you're describing. She said the Constitution's always become more embracive, embracing the left out people, not just grudgingly, but with open arms. And as you say, the cases kept coming to the court. Now, one series of cases that kept coming after Brown were cases involving marriage. And in many states in the Union, as incredible as it is to think about, Black and white people who loved each other could not get married because of these laws called anti-miscegenation laws that said that interracial marriage was illegal. And those laws were on the books until the 1980s or even longer. You'll tell us how long they persisted. Why was it that it took almost more than a decade between 1954 and the late 1960s, 67, for the court in the Loving and Virginia case to strike down those bans on interracial marriage? And what was the court holding when it did finally strike down those bans?
1967, the Loving case is truly extraordinary. I think it shows, again, the momentous shift when it comes to the Supreme Court. It shows this incredible move towards a greater equality that I think you can point to in American history, where we do try to do things better, even though we don't always get it right. And I think what Loving really represents is this extraordinary way of looking at, again, this relationship between what states are allowed to do, where we draw that line on the question of what is equal, what does equal really mean. But then again, thinking through Loving and thinking about interracial marriage and the striking down of those laws, one of the proudest interviews I got to do for the book was to interview the lawyer who argued Loving. Wow. And I will tell you, I just sat there in almost awe it was hard for me to even ask the questions because that is such an incredible constitutional case. And I'll just say this, they relayed to myself and my co-author very, very succinctly that if it felt like it was not just time for society to recognize that the Constitution had to protect the right of opposite race couples to marry, but it was time for that to be on a constitutional level federally. But even more importantly, it just felt like anything other than that was not where we were as a country. And that's how they wanted to argue. And I think it's extraordinary that that's where they go in. They make this argument that at the time, similar to what you see in early marriage equality cases, judges often couldn't even wrap their mind around what it meant for a same-sex couple to marry. So I know the same thing is absolutely happening when it comes to opposite race couples. And yet where we find that is you find a court that says, this is so core to our identity. This is so core to what it means to be American, that we have to ensure that this is a federal constitutional right that is guaranteed to all. And, Mildred and her husband, what an incredible couple, a great example of a plaintiff that did not necessarily want to be a plaintiff, but yet takes a case up to the Supreme Court and changes America forever.
That is amazing. What an astonishing opportunity to interview the lawyer. I want to ask you what you learned from that interview about the strategy, the legal strategy, and also what you or maybe the lawyer thought about the fact that for 10 years, Felix Frankfurter was getting these cases saying, after Brown, obviously it's unconstitutional to deny people who love each other the right to marry, but he refused to let the court hear the case because he thought the country wasn't ready. He thought there'd be such a backlash that it was better for the overall cause of equality just to wait 10 years until the country was ready. Was he right to delay, or was that a violation of fundamental rights?
That is one of the greatest ways of looking at legal realism. That is one of the most brilliant questions you can ask when it comes to thinking about legal realism. It is truly that type of question that we have to ask ourselves when it comes to interpreting some of these fundamentals. You see the exact same thing in marriage equality as you do here when it comes to opposite race marriages. Is it time? Is society ready? We don't think that the justices are supposed to and or should necessarily think that way, but that is legal realism. You have to have that baked into our understanding of our constitutional kind of democracy. And I think if we don't, then we lose our toolkit to unpack why things happen when they do, how things happen at the Supreme Court, how the court operates within the construct of the larger picture of our system at the federal level, and then beyond at the state and local level. And in so many ways, it's very similar to how the very first judges hearing marriage equality cases, and the first federal marriage equality case was brought by two Black women in Wisconsin, and the federal judge just didn't even know what to do. They just didn't even know how to grapple with some of these arguments because they were so, in some ways, foreign, that's where equality would reside. But yet it's that argument that ultimately prevails, no different than it's that argument that prevails in Loving. And I think, again, this comes back to what I would argue is this actually really great thing about our country, that we don't get things right all the time. But the path that we have chosen is a path of betterment. And that is something that not all societies can say. And it's something that I am frequently very proud of when I think about being a constitutional scholar.
The path of constitutional equality is a path of betterment. You put it so well, and that's so inspiring. Okay, now we have a big story to tell, which is the story you tell in your incredibly important book. And that's the story of the path the Obergefell decision in 2015. That's a lot of years between 1967 and 2015. Take us through the legal building blocks of it. What were the big cases that people had to draw on and also overcome, since the court was not always friendly to the rights of gays and lesbians during that period? And how did we get from Loving to Obergefell?
I think it is incredible to see that 50-year-esque history. And I think the story of marriage equality is one that is as intersectional as any other social justice movement, I can argue. You have couples that are of different races. You have all sorts of folks coming in and making early arguments in the late 60s about the federal level, federal constitution, gaining absolutely no traction, and realizing that there have to be other ways to approach this. And what you see in the 50-year history of marriage equality is something quite extraordinary. You see the functioning of our constitutional democracy. And why do I say that? Because in certain places in Hawaii, you see judges that are ruling on a state level to allow marriage equality, and then a constitutional amendment banning it. In Massachusetts, you see the state court for the first time agree that marriage equality is the law in the state, and then you see the legislature attempt to overturn that and fail. You see in Vermont this compromise come about where the Supreme Court says, yeah, you don't have to do marriage, but you have to offer something similar, which becomes civil unions. You see executives in cities like New York and San Francisco issuing executive orders protecting municipal employees and their same-sex partners. What you see governors trying to push legislation through like they did here in New York and failing, and then trying again and failing, and then trying again and making it so that New York's the largest and first state to pass legislation that guaranteed marriage equality. You see that incredible work at the local level and the state level. And so it's not just judges, it's the legislatures, it's the executives, it is this truly American look at how a social justice movement over 50 years can approach something as core as the equal right to marry, and then take that eventually, once you start to notch some of those wins, and then start taking that through the federal system, through the federal courts, and start knocking down both the laws that existed to prevent that from happening at the state level in certain states, the Defensive Marriage Acts that existed, the Federal Defensive Marriage Act that existed, and then finally taking it all the way to the court and the Supreme Court ruling in Obergefell that just like it had in previous instances, and that equality matters, and it doesn't just matter under the Equal Protection Clause. Equality also matters as a matter of substantive due process. And the fact that that is our constitutional history is so telling to all the other social justice movements out there, that there are ways to chip away at different parts of the pie, and uniquely American ways to do that because of our unique federal model. And that is something that's extraordinary. You can see the wins, the losses, and that 50-year history eventually leads to where we are today. And I think that that's an extraordinary, realistic view of how social justice movements can move that ball forward to form that more perfect union.
Wonderful. What a powerful way of telling that historic story. And maybe just one last beat before I turn it back to Curry, because our friends have so many questions. To review what the court's constitutional reasoning in Obergefell was, you used the phrase substantive due process, which of course we lawyers know, but it's always kind of good to remind ourselves what that means. That 14th Amendment, imperfectly recited from memory at the beginning, says no state shall deprive any person of life, liberty, or property without due process of law. That suggests that you generally can deprive people of liberty with due process, but the court has said that there are some liberties that are so fundamental, so important, so deeply rooted in our history and tradition that you can't deprive them even with due process. They're kind of sacrosanct. And as you say in Obergefell, the court said that the right to marry is one of those rights. It's a fundamental right, and if a right is fundamental, it has to be extended to all people on equal terms. And then you said it added on in the equality part of the 14th Amendment, and said that it denies gay people equal dignity, to deny them access to a fundamental right and an institution which has been considered one of the core civil rights of all time. How did I do in summing up the reasoning, and how would you sum up the reasoning in Obergefell for?
Oh, Jeff, I mean, that was brilliant. And I think in so many ways, what I always find fascinating is that we have a beautiful amendment. The text, the positivism here, the intent is beautiful. You can look at the history of how this was written and what it was intended to do, and it really is striking to see what the 14th Amendment's intent was. And then you can see this history where it's a tortured history of interpretation, and the fact that it comes back to the idea of substantive due process, essentially a natural law, human right. The idea that the court essentially says, it's not even just that we're, equal protection. It's a fundamental human right. And to say there are fundamental human rights that the law, our Constitution, will not allow the state to touch, that is in your court as an American, that is your liberty as an American. It is a fascinating way that the amendment has come over the years. And I think, Jeff, you would agree, if you and I were around when this was passed, we would not have said, oh, in 100+ years, this is where the 14th Amendment will be. I don't think I would have said at all. I would have had a totally different way of looking at this, I think, and said that in 100 years, there's going to be a very different way that we look at this. And there would be a very different way to marriage equality and to ensure other, protections under the amendment. But the idea that you can take something like natural law, natural rights, the idea of where that comes from historically, and then that's where you put marriage. You tie the entire jurisprudence circle right back from realism to natural law, natural rights, and human rights. That is an extraordinary showing of why constitutional law is not just so fascinating. It's an extraordinary showing of why it's such an important thing for everybody to understand. Doesn't matter if you're a lawyer, doesn't matter what age. This is part of our being as Americans, is to understand some of these fundamental concepts so that we know where it comes from and we know where we can take it and make it better in the future.
Yes, what a great way of summing up this amazing conversation. It is a fundamental part of who we are as Americans. And that's why, friends, it's so important to do exactly what you're doing, which is taking time on these magical Fridays together to understand the constitutional arguments and to see how the Constitution has been transformed over time. With great reluctance, only because I'm learning so much, I'm going to turn it back to Curry to give some questions from our friends.
And I've been beaming here behind the camera and enjoying this so much. And it's so like enlightening. And that's what we're seeing in the chat is just so much thankfulness and gratitude for opening our eyes and understanding that, building out our own toolkit of understanding the 14th Amendment and what it takes to make these big changes with the 14th Amendment. So Bonnie's question, since you talked about fascinating to look at the last 50 years, the last 100 years of the 14th Amendment, Bonnie's question is perfect for this. What does the future hold? So what future interpretations do you see using the 14th Amendment? Do you identify any other groups that haven't yet realized equal protection for the law? Or what are those other fundamental liberties that you think, and I know this is a little like magic 8-ball, what do you think is coming down through the courts that may say this is going to be where the 14th Amendment ensures this fundamental liberty, like marriage equality?
I would say this, and Jeff, definitely jump in. I would say that at the moment, you don't really have a super powerful equal protection person on the Supreme Court. You don't have a Ruth Bader Ginsburg who felt that that's the place to hang the hat when it comes to some of these arguments. And you don't even necessarily have a Justice Kennedy who thinks that it's a substantive due process place or argument, even though I think that now is an argument that is a lot easier to make necessarily, and is one that in the future will be interesting to see how it comes together. I would say this, I think it's fascinating that the Privileges and Immunities Clause has not gotten the attention that I think it should have when this amendment was written. I think it is even more fascinating to see that it is the justices you would not expect that seem to argue, like Justice Thomas, that maybe that's the place where these conversations should be had. He's written about that in dissents. He's talked about it when equal protection cases have come up before the court. And so I think you have to take the realism of the justices. I think that's very important to be cognizant of when you think about the future of any amendment. And then I think you have to recognize how historically we've gotten here, but then note that it can be a beautiful word on a page. It can be a beautiful, beautiful word on a page. You just put the First Amendment up at the National Constitution Center. I saw it when I was there. It was gorgeous. And yet the concept of free speech and expression has changed. I mean, these concepts change over time. The arguments you would make 100 years ago are different than the arguments you would make in front of the court today because of the realism of how this all works.
I forgot we snuck you in the back. Okay, 2 more questions real quick. Colin has a great question. And you talked about this, again, this toolkit for us understanding that it's not just one person in a moment in time and boom, everything changes, that there's all this strategy that goes behind it. There are all these moments that make things move forward or go back. And Colin's question is, how can we better teach the public about the 14th Amendment? And what should schools be doing better to foster a younger generation that understands our history and the societies, the battles within the society?
Do you want to go first?
Oh, I'm going to leave it to you, Christopher.
That's fine. Okay, I think that's fine.
We're completely,
I can totally do that.
In your hands. I'm learning so much from you. So
no, this is fine.
Yeah.
I think we have to recognize, and I think that this is something that we tried very hard to do at both of our organizations, the importance of ensuring that a civic and constitutional education is available from cradle through career. I think it's very important to recognize that every classroom is actually a civics classroom, because what civics and constitutional law really detail and talk about are relationships. That's all the law really is a structure of our relationships, and constitutional law most of all. And so I think every interaction is a civic interaction. Every time we think about how we make America better, every time we think about how we can make a difference, we definitely end up saying to ourselves, okay, we have to give people those tools. We have to do it in a way that's completely removed from politics. And I think it's one of the reasons that I'm so impressed all the time with the work that happens at the National Constitution Center is, we've all dedicated our time and our efforts to ensuring that as many people at any age are able to access just the knowledge, the history, and then the tools necessary to make change possible. And that is in a classroom, but the thing about civics is that our civics classroom is this. It's our everyday interactions. It's our conversations about complex topics. It's the fact that it's important to have a little bit of humility and listen to other sides of the coin. I think that's something that I try to do all of the time. I'm certainly never 100% successful, but that's not always easy to do. That makes it and puts the onus on all of us to really embrace the idea that that's part of what it means to be a part of this society. And that's okay. And it's something that I celebrate myself, and I think and hope that everybody here celebrates too.
Wow, I just have to say, Christopher, every interaction is a civics interaction. What a spectacular way to put it. You're getting a lot of love in the chat about how perfectly that encapsulates our joint missions. And I am so, I so agree with you that let's encourage our friends, everyone who's listening, you're engaging in a civic interaction right now by doing exactly what Christopher says. You're listening to complicated arguments. You're taking time in the middle of the day. You're setting aside your screens and your distractions and the immediate gratification of, finding out the latest bit of news, and you're digging in deep. And that, as a result, allows you to have the humility, Christopher says, which is so crucially important, to listen to competing points of view and exercise your faculties of reason to make up your own mind. So what you can do is take this civics interaction we've just had today, which you guys have every Friday that you join us, and engage your friends in a conversation about some of the issues we're talking about. You just learned some very important, deep, complicated, and meaningful things about the constitutional basis for the court's holding in the marriage equality case. And that there's so many questions that has opened up, including several in the chat. Will the Supreme Court uphold marriage equality in the future? Or if it overturns Roe v. Wade, might it also overturn the Obergefell case? These are among the most serious and important constitutional questions in America today. And you, uniquely as citizens, are able to answer them in a thoughtful way because you're taking the time to engage in this civil dialogue. So carry the beautiful spirit of these magical classes to all parts of your life, to the dinner table, to hang out with your friends. I know it's a little geeky, but we embrace our inner nerd, and we really think that it's meaningful, as it is. I mean, you can joke about it, but we know, in fact, that there's nothing more satisfying than listening respectfully to people who you may disagree with, and having a respectful civil dialogue about the most important issues of life and liberty in America.
That was amazing. And I knew this would be a love fest on the 14th Amendment and in the amazingness of all of our students. I'm going to ask you one, this is slightly torturous, Christopher, so I apologize. One last question. So we've been doing 14th Amendment all week. We've had Eric Foner. We've done our classes. Like, it's been an amazing week for us. And one of our teachers said one of my favorite lines of maybe the year, but definitely the month and the week. Ryan said, the Bill of Rights is the shield and the 14th Amendment is the sword. And I love that line around the 14th Amendment. And for our students walking away of all ages, how should they think of the 14th Amendment, and what is not just the value, but the power that it has? Can you think of it doesn't have to be that perfect, but a line that you could really help us hold on to as we go into those conversations with our families, with our friends, on a walk in nature, or at the lunchroom counter like Colin is right now, wherever you are?
The Constitution has always been and will always be a reflection of our society. I think that's one of the reasons why legal realism teaches us that things do change. And I think it's one of the reasons why we ground ourselves in text, we ground ourselves in history, but we also have to be realistic about how this operates. The 14th Amendment, again, made a fundamental change in the relationship of the states to the federal government. And I think that fundamental change ensured that some of the core principles that existed in the Constitution that just applied to the federal government before now are something that we all hold, and we can hold it at the federal government level and towards the federal government. And we can use that sword against the state governments too. And it's been done now for over 100 years. And I love that analogy. But I say this in kind of in addition to that analogy, is that I always say, I tend to be very optimistic. I tend to think very positively. I mean, Curry, you and I have had many conversations where, you can see that we get so excited over these things. And I think the reason is because the 14th Amendment, the 15th Amendment, I can spin our wheel that we were talking about before. We historically continue to move closer towards a better country. And the 14th Amendment is one of the greatest tools to achieving that. And that doesn't change depending on the court necessarily. In fact, it just maybe the arguments might change, but we have a history of doing better. And I think it's one of the things I always hold on to is that I know at the moment we may not be doing so well. There may be time, and I don't mean right now, I mean just generally, like there may be times where we may look and think, wow, the pendulum swung again. And now we have questions about how do we protect, this particular group of Americans. But generally speaking, we do better as we go forward. And so I say that, and I reiterate it because I want people to always come away from a constitutional discussion with hope and with a belief that because the Constitution is a reflection of our American democracy and constitutional democracy, that there's always a light at the end of the tunnel. And there's always a way to continue to move the realism closer and closer to that more perfect union.
And I absolutely love that. And it feels like constitutional hope is the theme of our month. And I love the idea that you just like manifested that in my head, that it also takes us to hold that shield and to use that sword. So there's energy around understanding our amendments, understanding our history, and embracing our constitutional skills at discussing it, understanding it, moving it forward, and learning about it and teaching others about it. So thank you so much for this wonderful day. Jeff, I know you're so unbelievably grateful, but I'll turn it over for you for last words.
Thank you, Christopher. Couldn't thank you enough. There's so much enthusiasm in the chat, and it's just a privilege to be in constitutional conversation with you. You are a model of constitutional light, hope, and an ever more perfect union. Thank you, and can't wait for the next time we are able to convene.
Oh, thank you so much for having me. It is such a pleasure. And I'm just so glad we were able to have a conversation with so many people here today.
Likewise. Have a great weekend all.
Thanks all.